So, another unanimous ruling from the Supreme Court. For the Supreme Court, it's all about language, reasonable suspicion, objective, reasonable belief, or probable cause. Shut fire. Shut fire. It triggers something in me that something has to be done. The Supreme Court issued a 9-0 unanimous decision telling a lower court exactly how they got the law wrong, sent the case back for reconsideration under the correct legal standard, and then watched as that same lower court completely ignored the instructions and doubled down on their original ruling. Anyway, this isn't a theoretical scenario about judicial defiance or a hypothetical about what happens when appellate courts disagree with the Supreme Court. This actually just happened in a critical Fourth Amendment case about when police can use deadly force, and the timeline is absolutely shocking. The Supreme Court handed down their unanimous ruling just 6 months ago. The lower court has already issued a new decision that appears to contradict everything the justices said, and now the case is likely heading right back to the Supreme Court for what could be an unprecedented rebuke of a circuit court that seemingly refused to follow direct orders. Once you understand what the original case was about, what the Supreme Court unanimously ruled, and how the lower court responded, you'll realize we might be watching a constitutional confrontation between different levels of the federal judiciary that could reshape how excessive force cases get analyzed across the entire country. We're going to be discussing a recent 9-0 unanimous ruling that was issued by the Supreme Court earlier this year. This case fundamentally involves the Fourth Amendment's protections against unreasonable searches and seizures, and specifically addresses when law enforcement activities involving excessive force actually violate those constitutional rights. This unanimous ruling issued by the Supreme Court came in a case officially titled Barnes versus Felix, and this case may already be heading back to the Supreme Court for re-review in just 6 months after the Supreme Court issued their supposedly definitive ruling. The reason this case is returning so quickly is that the Fifth Circuit Court of Appeals has issued a brand new ruling in this case claiming to decide it in light of what the Supreme Court said in that 9-0 decision. Yet the Fifth Circuit has once again ruled that the officer's actions are legally protected even under the totality of the circumstances approach that the Supreme Court explicitly ordered them to apply. And perhaps even more remarkably, even the banc panel of the Fifth Circuit, which consists of all active judges on that circuit rather than just a 3-judge panel, has now denied rehearing review to this case. The Fifth Circuit has engaged in what many legal observers consider very questionable review of this case after the Supreme Court remanded it back to them following their new ruling. And this really just sets this case up for re-review once again by the Supreme Court, and potentially a remarkably fast re-review timeline because the Supreme Court only issued their ruling in this case 6 months ago. It's extraordinarily rare for a case to return to the Supreme Court that quickly after the justices have already ruled on it once. Now, the underlying facts surrounding this case are critically important to understanding why it matters so much. Essentially, Roberto Felix Jr., a law enforcement officer working in the Houston area, pulled over an individual named Ashton Barnes for suspected toll violations. The automated camera system at toll plazas had apparently captured toll violations, and the vehicle may have even been a rental car that had accumulated unpaid tolls. The individual was pulled over by Officer Felix for this relatively minor infraction. The officer instructed Barnes to exit the vehicle, and Barnes initially opened the car door and appeared as though he was going to comply with that instruction, but then he suddenly attempted to drive away from the traffic stop, reacting in what he later claimed was a split-second decision. Officer Felix made the choice to jump onto the ledge of the moving car as it began to pull away, and then, while physically on the moving vehicle, he also made the decision to draw his firearm and shot Ashton Barnes twice, resulting in fatal wounds. As a result of this deadly incident, Ashton Barnes' mother filed a civil rights lawsuit against the officer, alleging that Officer Felix violated Barnes' Fourth Amendment rights by using excessive force during what began as a routine traffic stop for toll violations. Fire. On initial review, the federal district court granted summary judgment in favor of the officer by applying what the Fifth Circuit calls the moment of threat rule. The Fifth Circuit Court of Appeals ultimately affirmed that district court decision on appeal, explaining in their opinion that the moment of threat rule requires asking only whether an officer was in danger at the precise moment of the threat that resulted in his use of deadly force. Under this highly restrictive rule applied by the Fifth Circuit, events and circumstances leading up to the actual shooting are considered legally irrelevant to the excessive force analysis. The court instructs judges to look only at the split-second moment when the trigger was pulled, ignoring everything that happened before that moment, including the officer's own decisions and actions that may have created or escalated the dangerous situation. This case made its way all the way to the Supreme Court through the appellate process. On review, the Supreme Court this year in May issued a 9-0 unanimous ruling in favor of the plaintiff, Ashton Barnes's estate. The court held that any claim alleging a law enforcement officer used excessive force during a stop or arrest must be analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene, considering all available information. The Supreme Court emphasized that the inquiry into the reasonableness of a police officer's use of force requires analyzing the totality of the circumstances surrounding the incident. That analysis demands careful attention to all facts and circumstances relating to the entire incident, not just the final moment when force was used. In this case, the Supreme Court explicitly rejected the more limited moment of threat analysis that had been consistently used by the Fifth Circuit, and instead ordered that courts must apply the broader totality of the circumstances approach. The Supreme Court stated clearly that most notably the totality of the circumstances inquiry has absolutely no time limit. While the situation at the precise time of the shooting will often matter the most in the analysis, earlier facts and circumstances may bear significantly on how a reasonable officer would have understood and responded to later developments. Prior events may demonstrate why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous and non-threatening. The main thrust of that Supreme Court ruling was unambiguously rejecting the more limited scope of analysis that had been consistently applied by the Fifth Circuit, which was the restrictive moment of threat review. Instead, the Supreme Court ordered that the lower court, specifically the Fifth Circuit, needed to completely re-review this case using the comprehensive totality of the circumstances approach that considers all facts from the beginning of the encounter. After the Supreme Court issued this seemingly definitive ruling, the case was formally remanded back down to the Fifth Circuit for re-review, with instructions to apply the totality of the circumstances approach, as the Supreme Court had just explained in detail. Now, here's where things get truly remarkable and concerning from a judicial process perspective. Interestingly, the three-judge panel in the Fifth Circuit that had originally heard the case decided not to hold any oral arguments in this case or request any additional briefs from the parties in light of what the Supreme Court had just said in that new unanimous ruling. Instead, they simply ruled on the case on their own initiative without requesting any of those additional legal briefs that would normally be filed, and still ruled in favor of the police officer, despite the Supreme Court's instructions. In their new ruling issued after remand, the panel held that even under the totality of the circumstances approach that the Supreme Court had ordered them to apply, the officer's actions were legally warranted and reasonable. The panel reasoned that any vehicle flight inherently creates a deadly threat to officer safety, and that Officer Felix reasonably used lethal force to prevent what he perceived as a dangerous situation from escalating based on that relatively quick and sparse analysis in their new decision. The Fifth Circuit panel once again ruled in favor of the officer without substantially changing their legal conclusion, despite the Supreme Court's explicit instructions. Because of that surprisingly brief analysis in the new decision by the Fifth Circuit, issued without additional arguments or supplemental briefs, or even oral argument being scheduled, Barnes's attorneys then petitioned for the Fifth Circuit en banc panel to re-review this case and examine what the three-judge panel had just ruled. The petition argued forcefully that the new ruling by the three-judge panel directly contradicts what the Supreme Court had just said in their unanimous ruling, and that it even contradicted prior decisions and statements by Judge Higginbotham, who was actually on the panel and who had earlier stated in a concurring opinion that if they were required to use the totality of the circumstances approach, there was no possible way they could rule in favor of the police officer's actions being reasonable. Yet somehow, on re-review after the Supreme Court remand, that same judge joined a decision ruling in favor of the officer anyway. It conflicts with the Second Amendment's right to bear arms. The right to keep and bear arms shall not be infringed. We won't see changes overnight, but it's going to be quick. The petition urged for a rehearing en banc in the Fifth Circuit because the new ruling effectively creates what legal scholars call a per se rule, that officers may shoot essentially any fleeing driver even when the initial stop involved only a minor traffic violation or other low-level offense. The petition argued that this sweeping rule conflicts fundamentally with Supreme Court precedents and also contradicts long-standing precedents within the Fifth Circuit itself about fleeing vehicles and the principle that merely fleeing in a vehicle does not automatically justify deadly force by a police officer. However, the Fifth Circuit en banc panel just issued their order, and they denied rehearing review of this case without any detailed explanation. In this extremely brief notice issued by the Fifth Circuit en banc panel, they stated simply that the petition for panel rehearing is denied as no member of the original panel or any judge in regular active service of the circuit has requested that the court be pulled on rehearing en banc. The petition for rehearing en banc is denied. That was essentially the entire order, providing no reasoning or analysis. So, despite the Supreme Court issuing that 9-0 unanimous ruling explicitly stating that courts needed to apply the totality of the circumstances standard and completely re-review the case under that framework, the three-judge panel in the Fifth Circuit issued an extremely quick ruling that did not request any additional legal briefs from the parties, did not schedule or hold oral arguments, and simply issued a new ruling, reaching essentially the same conclusion they had reached before. And then when the plaintiff's attorneys tried to get en banc review from the full Fifth Circuit, that request was also quickly rejected without meaningful explanation. This procedural sequence is genuinely remarkable and concerning from a judicial administration perspective. It's highly unusual for an appellate court to receive explicit instructions from the Supreme Court in a unanimous decision and then essentially ignore those instructions and reach the same conclusion they had reached before using reasoning that appears to contradict what the Supreme Court said. This is absolutely something the legal community will be watching closely to see how it develops. It's genuinely surprising that the Fifth Circuit panel decided to issue a brand new ruling on this case without requesting any additional briefing or holding oral arguments in light of what the Supreme Court had just said in that 9-0 unanimous decision. And now even the en banc panel has denied re-review of this case despite serious concerns about whether the lower court ruling properly applied Supreme Court precedent. This procedural history now sets this case up perfectly to return to the Supreme Court in just 6 months after the court issued that 9-0 unanimous ruling and remanded the case for the Fifth Circuit to re-review the excessive force issue under the correct legal standard. The plaintiff's attorneys argue forcefully that the Fifth Circuit has completely failed to properly apply the new ruling issued by the Supreme Court, and they may very well return to the Supreme Court once again and ask the justices to step in and directly correct what the lower courts are doing. They may argue that the Fifth Circuit is simply defying the Supreme Court's clear instructions and that the Circuit Court doesn't want to rule in a way that actually aligns with what the Supreme Court unanimously said all 9 justices agreed upon. If the Supreme Court takes this case again, it could result in an extraordinary rebuke of the Fifth Circuit and potentially establish even clearer standards for how excessive force cases must be analyzed. The justices might be particularly concerned that a circuit court appeared to ignore their unanimous instructions and reached essentially the same conclusion using reasoning that seems to contradict the Supreme Court's explicit guidance. This could also raise broader questions about what happens when lower courts don't faithfully implement Supreme Court decisions and whether the Supreme Court needs to take additional steps to ensure their rulings are actually followed rather than just nominally acknowledged. The timeline here is remarkable. Supreme Court issues unanimous ruling in May. Case gets remanded. Fifth Circuit issues new decision within months. reaching the same conclusion, and banc review gets denied. And now the case is likely heading right back to the Supreme Court before the end of the year. That's it for today, folks. See you in the next video.